In the United States, enforcement of antitrust laws isn't just limited to the government. Private individuals can also sometimes sue companies for antitrust violations. But who is allowed to bring these private lawsuits? The Supreme Court revisited that question in Apple v. Pepper. In 2011, 4 iPhone app customers brought a lawsuit against Apple, claiming that Apple had an illegal monopoly on the market for iPhone apps. Under Apple's contracts, app developers can only sell their apps in Apple's App Store and nowhere else. Apple charges a 30% commission on each app sold through the App Store. The iPhone owners claimed app prices would be lower if developers could also sell their apps in other places where they didn't have to pay the commission. One of Apple's defense arguments was that the direct purchaser rule from the 1977 Supreme Court case Illinois Brick barred the suit by the app purchasers. Under Illinois Brick, only the person who first pays an alleged monopolistic overcharge can sue the alleged monopolist. Because Apple charged the 30% commission to the developers and not to the iPhone owners, the app developers might or might not have passed on some of that 30% charge to the iPhone owners who purchased their apps. The developers, not the app buyers, were directly charged the 30% commission, and so Apple argued that only the developers should be able to sue. Justice Kavanaugh wrote the majority opinion, joined by Justices Ginsburg, Breyer, Sotomayor, and Kagan. The court held that the app buyers could sue Apple because the money the app buyers paid flowed directly to Apple. The developers were not intermediaries in that transaction. Illinois Brick's direct purchaser rule was intended to be a bright-line rule, grounded on the belief that simplified administration improves antitrust enforcement. In a dissenting opinion, Justice Gorsuch, joined by Chief Justice Roberts and Justices Thomas and Alito, argued that the direct purchaser rule in Illinois Brick was not intended to give consumers the right to sue every company with whom they are in contractual privity. Instead, the rule was meant to permit antitrust suits only by the first party in the chain to suffer an overcharge, in order to eliminate the difficult and uncertain process of figuring out whether the overcharge had really been passed on. Because the majority found that the consumers could sue Apple, the case is headed back to the lower courts to evaluate whether Apple actually did exercise monopoly power over app prices. But the majority opinion in Apple v. Pepper could give tech companies a roadmap to avoid consumer suits in the future. Justice Gorsuch predicts that those companies will simply restructure their payment systems so that consumers' money flows directly to the developers rather than through an online store, to avoid the contractual privity that could expose companies to antitrust lawsuits from consumers.